Rome believed its laws made it eternal. But behind public trials and sacred oaths, verdicts were bought, power went unpunished, and justice became theater. This is the true story of how corruption didn't overthrow Rome by force. It hollowed the law from the inside. Chapter 1: The Myth of Roman Justice. Rome presented itself as a civilization governed by law rather than the will of a single ruler. This belief was central to Roman identity. Long after the kings were expelled in 509 BCE, Romans defined themselves as cives, citizens protected by legal rights, not subjects ruled by force. By legal rights, not subjects ruled by force. Law was not just a system, it was a symbol of Roman superiority. The foundation of this belief rested on the 12 Tables, codified around 450 BCE after intense social conflict between patricians and plebeians. For the first time, laws were publicly displayed, written in bronze, and theoretically applied to all free Roman citizens. Romans believed this transparency distinguished them from monarchies and barbarian societies governed by whim. Cicero later claimed that Rome was held together not by walls or armies, but by law. Roman courts, legal rituals, and magistracies reinforced this image. Trials were public, offices were temporary, judges were meant to embody restraint and civic duty. To Roman eyes, justice was proof that their republic, and later their empire, was morally ordered. Yet beneath this ideal, contradictions appeared early. Legal expertise remained concentrated among elites. Access to justice depended heavily on social standing, wealth, and patronage. While the law was written, its interpretation was controlled. Procedures favored those who could afford time, connections, and influence. Even as Romans celebrated their legal tradition, justice was already becoming performative, an outward display of fairness masking unequal outcomes. The system looked impartial, sounded authoritative, and claimed universality. But in practice, law often served power rather than restrained it. The question was not whether Rome had laws, it was whether those laws still governed Rome, or merely justified those who ruled it. Chapter 2: Power without accountability. Roman justice depended not on independent institutions, but on the men who temporarily held power. Magistrates such as consuls, praetors, and governors were entrusted with immense authority over courts, finances, and punishment. In theory, their terms were limited and their actions accountable to the Senate or the people. In practice, oversight was weak, delayed, or entirely absent. Praetors, who presided over courts in Rome, controlled which cases were heard and how legal formulas were applied. Governors sent to provinces wielded even greater power. They combined civil, military, and judicial authority in a single office. A provincial governor could arrest, fine, exile, or execute non-citizens with little immediate consequence. Appeals to Rome were slow, costly, and often meaningless. Temporary office was supposed to prevent abuse, but it created new incentives. Many officials entered office already burdened by debts from political campaigns. Provincial appointments became opportunities to recover losses and build fortunes. Cicero's prosecution of Gaius Verres in 70 BCE exposed how a governor of Sicily extorted cities, manipulated courts, and plundered temples, actions widely known, yet rarely punished. Even when laws existed to curb corruption, enforcement relied on the same elite class accused of wrongdoing. Trials often occurred years after abuses, when political alliances had shifted and witnesses were gone. Convictions were rare, acquittals were common. Justice increasingly became a pathway to power rather than a restraint upon it. Legal authority elevated careers, secured wealth, and strengthened political networks. The system assumed virtue would regulate behavior. Instead, ambition filled the vacuum. Rome did not lack laws. It lacked mechanisms to ensure that those who enforced them were bound by the same rules. Chapter 3: Justice for Sale, Bribes, Favors, and Influence. By the late Republic, corruption in Roman courts was no longer hidden, it was expected. Bribery, known as ambitus in political life and pecunia in legal contexts, had become an open secret. Judges were drawn from the senatorial and equestrian orders, the same social class as the accused. Verdicts were shaped less by evidence than by wealth, reputation, and alliances. Trials could be delayed indefinitely through procedural tactics, often until public interest faded or key witnesses disappeared. Wealthy defendants hired renowned advocates like Cicero or Hortensius, whose presence alone influenced juries. For the elite, the law offered flexibility. For the poor, it offered finality. Patron-client relationships further eroded impartiality. A powerful patron could shield clients from prosecution or ensure favorable judgments. In return, loyalty was expected, political support, silence, or future favors. This informal network operated alongside formal law, often overriding it. Legal inequality became systemic. Roman citizens already enjoyed privileges denied to non-citizens. But within citizenship itself, status mattered. Senators and equestrians were rarely subjected to punishments imposed on lower classes. Fines replaced corporal penalties. Exile was replaced execution. Justice adjusted itself to social rank. Contemporary writers did not deny this reality. Sallust described a republic where everything was for sale. Cicero acknowledged that verdicts could be purchased, even as he defended the system. Corruption was not viewed as a breakdown, it was seen as an unfortunate but functional feature. The courts still operated, laws were still cited, but outcomes were increasingly predetermined. Roman justice had not disappeared. It had been priced. Chapter 4, Provincial Courts, where law went to die. Nowhere was the collapse of Roman justice more visible than in the provinces. Governors appointed from Rome exercised near total authority over territories they barely understood, and populations that held little political value. In these regions, law existed almost entirely at the discretion of a single man. A provincial governor combined multiple roles: chief administrator, military commander, and supreme judge. There was no separation of powers. Trials were often summary, evidence informal, and punishments severe. For non-citizens, there was no right of appeal. Even Roman citizens faced delays so long that justice became irrelevant. Extortion, known as repetundae, was widespread. Governors demanded payments for favorable rulings, tax relief, or even basic protection. Cities were forced to fund lavish lifestyles, public games, and private estates. While laws existed to prosecute such abuses, these trials took place in Rome, far from the victims and years after the crimes. The case of Gaius Verres exposed this reality but did not end it. His conviction was exceptional precisely because corruption was normal. Most governors returned home wealthy and celebrated. Provincial suffering rarely translated into accountability. Distance from Rome intensified abuse. Communication was slow. Oversight depended on political will. Local elites often collaborated, benefiting from the system while their communities suffered. This provincial corruption had consequences beyond economics. It undermined Roman legitimacy. Subjects obeyed Rome's power, not its justice. Law became a tool of extraction rather than governance. An empire that claimed to rule by law could not enforce it where it mattered most. In the provinces, Roman justice did not merely weaken. It ceased to function. Chapter 5, The Death of Civic Virtue. Roman justice was never sustained by laws alone. It relied on a shared moral framework rooted in mos maiorum, the ancestral customs. That emphasized duty, restraint, and service to the state. In the early republic, public office was framed as an obligation, not a business opportunity. By the 1st century BCE, that ethic was fading. Political competition intensified as Rome expanded. Military victories brought immense wealth, and success became measured in land, slaves, and influence rather than civic reputation. Offices once associated with sacrifice were now pathways to enrichment. Legal authority followed the same trajectory. Writers of the period recognized the shift. Sallust blamed Rome's moral decline on luxury and greed. After the destruction of Carthage in 146 BCE, with no external rival to restrain ambition, internal competition turned destructive. Law became another instrument in personal advancement. Public response changed as well. Citizens increasingly viewed courts with cynicism rather than trust. Jury service was treated as a favor to be traded. Legal outcomes were anticipated, not debated. When injustice became predictable, outrage diminished. This apathy mattered. A legal system survives only when people believe it reflects shared values. As that belief eroded, corruption no longer provoked resistance. It became routine. Roman justice did not collapse in a single moment. It decayed as civic virtue weakened. Laws remained intact, rituals continued, and verdicts were issued. But the moral foundation that once restrained power had eroded. When justice is no longer tied to duty or honor, it becomes transactional. Rome learned that lesson slowly, and at great cost. Chapter 6: Emperors above the law. The rise of the Roman Empire transformed the legal system without formally dismantling it. Republican institutions survived in name, but real authority increasingly rested with the emperor. In theory, the emperor was the guardian of justice. In practice, he stood above it. Imperial power granted immunity. Emperors could not be prosecuted, and there will often determine legal outcomes. Courts became instruments of political security rather than impartial judgment. Charges such as treason or maiestas were expanded to silence critics and confiscate wealth. Under Tiberius, treason trials multiplied, enriching informers and intimidating the Senate. Under Nero, legal proceedings justified executions and property seizures framed as lawful punishment. Due process remained outwardly intact, but verdicts followed political necessity. Even well-intentioned emperors contributed to the problem. By centralizing authority, they weakened independent legal traditions. Appeals increasingly flowed upward, making justice dependent on imperial favor. What could not be obtained through law could often be secured through proximity to power. The emperor's court replaced civic courts as the center of legal gravity. Justice became personal. Outcomes varied according to mood, advisors, and political risk. The law did not disappear under the emperors. It was repurposed. Trials continued, judges presided, and procedures were followed, but guilt and innocence were increasingly defined by loyalty rather than evidence. When power determines legality, law becomes an extension of survival. Rome preserved the language of justice while hollowing out its substance. Chapter 7: Reform attempts that failed. Rome was not unaware of its legal corruption. Laws were passed repeatedly to restrain abuse, limit extortion, and regulate judicial conduct. Yet reform consistently failed, not because solutions were unknown, but because enforcement depended on those with the most to lose. During the Republic, courts such as the Quaestio de Repetundus were created to prosecute provincial extortion. Jury compositions shifted between senators and equestrians in an effort to reduce bias. Each reform promised accountability. None addressed the underlying incentives that rewarded corruption. Under the empire, emperors issued edicts condemning bribery and judicial misconduct. Augustus promoted moral legislation and public virtue while consolidating personal authority over legal outcomes. Later, emperors announced reforms but rarely punished powerful offenders unless politically convenient. The core problem remained unchanged. Officials were judging officials. Social class shielded defendants. Political alliances softened verdicts. Convictions occurred, but selectively. Reform functioned as reassurance rather than correction. Legal complexity also worked against accountability. Procedures multiplied, appeals lengthened, and cases stalled. Time protected the guilty. Victims lost resources or influence before trials concluded. Reform became symbolic. It preserved the appearance of justice while avoiding structural change. Laws existed on parchment, not in practice. Rome could diagnose its corruption. It could not cure it. A system built on personal power and elite consensus could not discipline itself. Each failed reform deepened public skepticism, reinforcing the belief that justice was an illusion maintained for stability, not fairness. Chapter 8: When people stopped trusting the law as Roman justice lost credibility. Its social consequences became unavoidable. When courts no longer offered protection or fairness, people sought alternatives. Disputes were settled through influence, intimidation, or violence, rather than legal process. In cities, local strongmen and patron networks replaced formal institutions. Loyalty shifted away from the state and toward individuals who could offer protection. Legal outcomes mattered less than personal connections. The law remained present, but it was no longer trusted. This erosion affected military discipline as well. Soldiers increasingly followed commanders rather than institutions, mirroring civilian patterns. Justice administered by rank or favoritism weakened cohesion and accountability. Legal collapse contributed to broader instability. Tax resistance, corruption among officials, and resentment in the provinces intensified. Subjects obeyed Rome out of fear or habit, not belief in fairness. Once that belief vanished, enforcement required greater force. Imperial authority responded with harsher punishments and expanded surveillance. Rather than restoring trust, this reinforced alienation. Law was experienced as threat, not protection. The Roman state still functioned, but its moral contract with its population had fractured. Justice no longer unified society, it divided it. A legal system survives on legitimacy. When people stop believing that law serves them, compliance becomes conditional. Rome crossed that threshold gradually, but once crossed, recovery became nearly impossible. Corruption had moved beyond courts, it had reshaped behavior itself. Chapter 9: The Long Collapse of Roman Justice. The collapse of Roman justice was not marked by a single decree or moment of failure. It unfolded slowly, embedded within institutions that continued to function in form but not in spirit. Courts remained active, laws were cited, officials issued rulings, yet justice no longer carried authority, it carried procedure. Corruption weakened Rome's capacity to govern itself. Legal inequality deepened social divisions. Provincial exploitation reduced loyalty to the state. Military discipline suffered as favoritism replaced accountability. Economic confidence declined when contracts and property rights depended on influence rather than law. By the late Empire, legal inflation became a substitute for justice. Emperors issued thousands of edicts attempting to regulate behavior that courts could no longer control. Punishments grew harsher, not fairer. Coercion replaced consent. The irony was profound. Rome continued to describe itself as a civilization of law, even as belief in that law evaporated. The legal tradition survived in codes, commentaries, and ceremonies, but it no longer restrained power or protected the vulnerable. When external pressures mounted, economic strain, internal division, and foreign invasion, Rome lacked the institutional trust needed to respond cohesively. An empire that once prided itself on justice could no longer rely on it to hold society together. Rome did not fall because it lacked laws. It fell because too many people stopped believing those laws meant anything. An empire can survive enemies at its borders. It cannot survive the collapse of faith in its own justice. Roman justice did not collapse because its laws vanished. It collapsed because belief in those laws did. Corruption turned institutions into performances, power into privilege, and justice into a transaction. That pattern is not ancient, it is human. If history matters to you not as myth, but as warning, if you believe empires are undone from the inside, long before they fall from the outside, then this channel exists for that purpose. Subscribe to continue exploring the real mechanics of power, corruption, and collapse, through verified history, real consequences, and stories that still echo today.